Welcome to Module 2, the Fundamentals of International Criminal Justice. My name is Professor Rashmi Raman and I will take you through understanding the sources of international criminal law. To study the various sources of international criminal law and to learn the general principles of international criminal law are the two purposes of this module. The sources of international criminal law come from Article 38 of the Statute of the International Court of Justice. Article 38 of the Statute of the International Court of Justice has a very interesting and important history of codification. Article 38 is considered the sources of international law. What does this mean? International law comes from various avenues that states and judiciaries have decided. These avenues include treaty law, which is codified and written down versions of what states believe to be their legal obligations. Therefore, treaty law forms Clause A of Article 38(1) of the Statute of the ICJ. The second source of international law is customary international law. Customary international law are the unstated, unrecorded, uncodified obligations that existed between states since times immemorial. However, an exception to this is instant custom, or sources of law that are technology driven and evolve almost as state practices evolve. These reflect the state of the art in state practice and are uncodified but constitute a very important source of international law. Customary international law has two components, state practice and opinio juris. State practice, as the name suggests, is the practices of states. These are revealed through internal documents, external sources, verifying and vetting how states behave in a given legal situation. And opinio juris is the mental element of state practice. Opinio juris expands to opinio juris sive necessitatis. This means such sources of law whose conduct is driven by a belief that states believe is important and in fact creates a binding legal obligation upon them. Together, opinio juris and state practice are the two sources that courts will look at when they try to determine customary international law. The third source under Article 38 of the Statute of the International Court of Justice is state practice or general principles of international law recognized by civilized nations. Now this, despite the somewhat controversial nomenclature, was adopted in 1945 along with the Statute of the International Court of Justice and basically means such rules of conduct as civilized states, that is, the Western superpowers. Today, of course, this includes all states, 192 or 193, depending on your political leanings, that make up the international community. Practices made by the state that reveal what they believe the state of international law to be, therefore becomes source 3. The final source is Article 38(1)(d). Now, Article 38(1)(d) starts by calling itself subsidiary. This could mean that it is in fact inferior to the sources given above it, 38(1)(a), 1(b) and 1(c). There is in academia a debate known as the hierarchy of sources debate. Should you be interested in this debate, I urge you to look at further sources on it. For our present purposes, the sources of international criminal law come from Article 38 of the Rome Statute of the International Criminal Court. Now, Article 38 of the Rome Statute actually imitates Article 38 of the Statute of the ICJ. It talks about treaty-based sources of international criminal law, customary law, judicial practice, the general principles of international criminal law, the principle of legality, or nullum crimen sine lege, and finally, Article 21 of the Rome Statute. There are 5 sources of international criminal law which are formally enumerated in Article 38(1)(a). These are treaties, customary international law, general principles of law, judicial decisions, and writings of eminent jurists. Article 38 of the Statute of the International Court of Justice brings out the sources of international criminal law that regulate the relations between sovereign states. In international criminal law, the application of written law takes over the customary law, which means that treaty law supersedes customary international law. It is important that the general principles of law are maintained and applied while using treaties, as they enshrine the very basic principles of criminal law. Treaties act as a source of international criminal law either directly or indirectly. Those international criminal statutes or conventions that are a result of a treaty are direct sources. Those sources which emanate from already existing treaties are also called subsidiary sources. The sources of law that are direct result of treaty formations are international military tribunals, and the Rome Statute conventions have been adopted as a result of treaty formation. Sources of law include the Hague Convention, the Geneva Conventions, the Genocide Conventions, and the Torture Convention. Other treaty-based sources of international criminal law are the Statute of the International Criminal Tribunal for former Yugoslavia, the Statute for the International Criminal Tribunal for Rwanda. These were created on the basis of Security Council resolutions from the United Nations. The resolutions of the UN Security Council are binding on all member states according to Article 25 of the Charter of the United Nations. The ICCPR and the Rome Statute adopt the principle of nullum crimen sine lege, which indicates that all written law in international criminal law will always be preferred over any other form of law. The treaties are interpreted using the provisions of the Vienna Convention on the Law of Treaties, 1969. Article 38(1) of the ICJ statute points out that there are two elements of custom as we discussed previously. The first one is state practice and the second one is opinio juris, or the mental element of the state. Not only must the acts concerned amount to a settled practice, but they must also be such or be carried out in such a way as to be evidence of a belief that this practice is rendered obligatory by the existence of a rule of law requiring it. The Nicaragua decision of the International Court of Justice has said that opinio juris must be backed by actual state practice to allow the rule to be enunciated as an existing rule of international law. A criminal prosecution cannot be held solely on the basis of customary international law. Although, if the custom turns into a codified form, then the concerned principles from that treaty may and have sometimes been used. Judicial practice is one of the sources of international criminal law. These can be used when the courts affirm the existence principle of international law by pointing to the practice and pre-existing opinio juris from other courts. When courts try to declare a norm as custom through their decisions, these form an important precedent for future courts. The judicial practice which paves way to the sources of international criminal law works through the process of crystallization of judicial decisions. A normative claim is considered as an emerging international law, in which case the majority of states will be polarized to give rise to an actual principle of customary law. General principles of international criminal law must be resorted to when the existing law fails to provide any provision for a circumstance. These principles are tested with time, and some of them exist since historical times. Some of the most important general principles of international law are the principles such as the principles of legality, of specific presumption, presumption of innocence, the principle of equality of arms, the principle of command responsibility, etc. National legal systems have adopted two forms of criminal justice, the first being substantive justice and the second strict legality. In substantive justice, it does not require the existence of a law to penalize a wrongdoing. However, the doctrine of strict legality requires the pre-existence of a law before an individual is prosecuted. In the early phases of international law, substantive justice was given primacy. However, Article 21 of the Rome Statute, which lays down what is known as the applicable law under the International Criminal Court, lays down for us a hierarchy in the applicable law. The highest in the hierarchy is the Rome Statute, which is the codified version of customary international law. Elements of crime and the rules of procedure and evidence also make up the Rome Statute. The Rome Statute has an extensive list of crimes that can be tried in the International Criminal Court. These crimes include genocide, crimes against humanity, terrorism, war crimes, and the crime of aggression. However, crimes that are born from customary principles of international law, which are yet to be codified, may not be tried before the International Criminal Court. There is an interesting debate on what these crimes might be. We will see in the coming modules what the flaws and the drawbacks are of this kind of principle of legality under the ICC. For now, in this module, you have understood what the sources are of international law. Firstly, the sources come from the Rome Statute, which mimics the Statute of the International Court of Justice, Article 38(1). These sources are formalized as codified sources, that is treaties, conventions, rules, and principles and statutes that have been adopted by ad hoc as well as permanent courts. Secondly, customary international law. Thirdly, general principles of law accepted by states. Finally, judicial decisions and the writings of jurists. Together, these make up, along with Article 21 of the Rome Statute, which lays out what the applicable law is, the sources of international criminal law. Thank you.